So what we're going to be talking about today is utilizing H-2B visas for the construction industry. The construction industry is a big user of the H-2B visa program, and so let's talk about how that works. So right now, there's roughly 25% more unfilled construction positions than there are hires. I think that everyone in construction is familiar with this problem. It's hard to find people. When you do find people, it's really hard to find the good ones. The prices of these people have gone up significantly, and it's tough. It's tough to run a construction company right now that uses a lot of labor. The sector's unemployment rate is really low, 3.8%. With that is also a ton of competition between construction companies. So there's been a lot of lateral movement as well, which wouldn't be captured in the unemployment rate. So there's a separate issue there, which is a retention rate issue. And that's, if you're in the construction industry, you're all too familiar with that as well. As I'm sure you're also aware, construction input prices have increased considerably, 21.4% year over year, which is just crazy. And a lot of this is related to labor. A lot of it's related to materials too, in terms of the actual input prices, but labor has been a huge issue for the construction industry, which is in part why the construction industry has continued to rely more and more heavily on H-2B visas. So let's talk a little bit about H-2B visa basics. What is the H-2B program? The H-2B visa program is a temporary or seasonal non-agricultural visa. It's used a lot in the construction industry. It's used a lot in landscaping. It's for unskilled positions, quote unquote, unskilled positions, which is generally a term that is referring to education levels. So people that don't need a college degree normally. And the way that it works is it is numerically capped. So there's a cap of 66,000 visas. And the way the government allocates those 66,000 available visas is based off the government's fiscal year. The government's fiscal year starts on October 1st. So the government's October 1st is a calendar year's January 1st. That's the first day of their fiscal year. And so they allocate 33,000 of the visas for October 1st and 33,000 of the visas for April 1st. The way that these applications work is the first thing that you file is what's called a prevailing wage determination. This is where you disclose to the Department of Labor the type and location of the work that you intend to perform, and they will send you what's called a prevailing wage determination to ensure that you're not adversely affecting the wages and working conditions of U.S. workers similarly employed in the area of intended employment. So that's the first step in the application process. Whenever you're actually submitting your application into the lottery, there's a 3-day filing window. So, for example, this next filing window to have an April 1st start date will be from January 1st to January 3rd. So on New Year's at Farmer Law, we are submitting H-2B applications. And what the Department of Labor does at this point, we're filing with the state workforce, we're filing job orders with the state workforce agency, filing this form is called a 9142B with the Department of Labor. And what the government does at this point is they take all those applications and they assign them groups, A through G. So this many in Group A, Group B, Group C, Group D, Group E, F, and G. There were enough applications in Group A, for example, to actually take up all of the available visas. So basically, if you don't get Group A, particularly for an April 1st start date, don't count on getting your workers for an April 1st start date. Though you're going to request a specific number of workers, and in this case for April 1st start dates, for example, it was really competitive. We'll actually get into that here in a little bit, but there were 130-ish thousand people applied for with only 33,000 spots. So it was really, really competitive. But what happens is a lot of times people B through G didn't get their workers for April 1st start dates. So what does the government do? Almost every year, the government issues what's called a cap increase. And the cap increase just allows for people after April 1st to bring in their workers because the government's issuing more visas than are approved in the actual regulations. So this is through a supplemental regulations that they do every year, usually in December. And they consistently do this. The only time I haven't seen a cap increase was during COVID, and I think that was in large part just because it would be poor form to have a whole bunch of U.S. people out of work, but still allow for a lot of additional non-immigrants to come in and fill other roles that are currently available. So the length of the process, 150 days before the start date's optimal. And that's still even on a little bit on the aggressive side. If you could do 180 days, that's even better. So you want to start the prevailing wage determination pretty early on. There's no reason not to just get the prevailing wage determination out of the way. There's a statutory requirement that you file the application no less than 75 days in advance, no more than 90 days. So you got to have plenty of time to prepare that application. So when should you start the process? 5 to 6 months before the start date. So if you're looking for an April 1st start date, start the filing process in October. If you're looking for an April or for an October start date, you'll start in April. The reason that we suggest this is because there are aspects of the application process that are pretty unpredictable. So for example, historically, the Department of Labor has been processing prevailing wage determinations in 30 days or less. Well, all of a sudden this year, they decided that they were going to start taking 45, 50 days to process prevailing wage determinations. And so if you were on a tight timeline, you wouldn't have been able to file during the filing window. You don't file during the filing window, you're not getting Group A. You don't get Group A, you're not getting your people. So start this process well in advance, plan for it, because it's going to have a huge implication on your likelihood of success in the application process. So let's talk about what are some of the occupations that use H-2B visas. So general construction labor, general labor, carpenters, carpenter helpers, concrete finishers, steel workers, rebar workers, machine operators. There's all kinds of potential occupations. Basically, if you're in construction, someone's using H-2B to fill that type of work also. So here are just some questions that we get pretty regularly. I have a year-round business. Can I still use the H-2B program? After all, the H-2B program is temporary or seasonal in nature. And so what's important here is that we define those terms. What does it mean to be temporary or seasonal in nature? There's 4 ways to define this. There's a seasonal need. A seasonal need is a need that is only occurs during a particular time of year. So if I have a snow removal company in Vail, Colorado, I only need workers when it's snowing. It's not doing a lot of snowing in the month of August and the month of July. And so I don't need workers during that time to perform snow removal services. So that is a seasonal need because it only occurs at one time a year. There's an intermittent need. An intermittent need is a need that happens on certain increments, but are not necessarily seasonal. So for example, let's say I own a memorabilia production company, and I am given the privilege of every 5 years during the 5-year anniversary of the Super Bowl to produce 5-year anniversary celebratory memorabilia for the NFL. That would be an intermittent need because I need it every 5 years. There's what's called a one-time occurrence need. A one-time occurrence need is when you wouldn't ordinarily need workers to perform this job function, or you wouldn't ordinarily need temporary workers to perform the job function, but due to a certain occurrence or events, you do. So for example, let's say that I have a need for additional workers because I have a backlog of work that was created due to the COVID-19 pandemic. And I need workers to work my way through the backlog created through the pandemic. I can use a one-time occurrence argument to justify that so long as I can actually support it with the necessary evidence. And then there is the most commonly used justification for H-2B workers, which is a peak load need. A peak load need is when I have a year-round need, but because of some seasonal event or occurrence that is predictable, I have an increased need during a certain time of year. So, for example, in Central Texas, let's say I have a landscaping company. Well, I can employ landscapers year round because there's some landscape that needs to be done year round. But during the months where the grass is growing, particularly March-ish through November-ish, I have an increased need for workers because I've got a lot more work to do. That's when I've got to really mow, got to do a lot of weed eating, got to do a lot of irrigation work, those sorts of things. That's called a peak load need. That's the one that's used most in construction. And we see it all the time. I mean, if you're talking about, let's say that I own a carpentry company or a framing company in Des Moines, Iowa. Well, I can frame year round. I can. But during the months of January and February, the number of days I can frame are significantly reduced. Or let's say I own a concrete company in Texas, and I do a lot of TxDOT work. Well, TxDOT has some specific requirements for when you pour concrete and the weather conditions outside. And so there are certain times of year where it's more conducive for that. And so do you have a year-round business? Yeah, because you perform year-round work. But can you still utilize H-2B workers? Yes, you can. And it would be under one of those needs, most commonly the peak load need. Okay, I have not been able to secure workers under the April cap yet. Do I still have a chance to try again? Yeah, so there's a few ways to do this. The most common way to do it is through a cap increase. So every year they'll do a cap increase, and this usually results in workers arriving in June. There's other ways to still get in workers. We're not going to go into all those details today, but the most commonly used way is, in fact, the cap increase. What does the DOL look for when certifying applications? Well, a lot of stuff. But they look primarily to just, well, I guess the job of the Department of Labor in the certification process is to ensure, A, that you're not adversely impacting the wages or working conditions of similarly employed U.S. workers in the area of intended employment. The other thing they're looking for is to make sure that your application actually meets the regulatory framework, the regulatory requirements of the application, such as you're demonstrating the need for the number of workers during that time of year, and that you're able to demonstrate that your business is temporary or seasonal in nature. So it's number of workers, temporary or seasonal in nature. Those are the two biggest ones, making sure that your job order is consistent with your application and making sure that you're not adversely affecting the wages and working condition of U.S. workers. So it is a pretty complicated process. But if you have a law firm that's worth their weight, they can walk you through it. Do I have to provide housing and transportation? Under the H-2B regulations, you're not required to provide housing and transportation. What I normally see, though, is that employers do in some way provide housing and transportation and then deduct the cost of it from the workers' checks. So long as that is disclosed on the job order, that's permissible. And the other thing is you can't deduct more than the actual cost. So if it actually cost me $1,200 to rent this house, I can deduct $1,200 to rent this house. But I can't deduct $1,400 for my administrative fees also. Okay, how many workers requested for October 22 start date during the filing window? Oops, we actually have these backwards. How many workers requested for October 22 start date? That one was the one that was 29,000 roughly. How many workers were requested for April 2022? That one was the 130,000. Sorry about our mix up here on our slideshow. That's my fault. I was reading through this and I didn't notice that. But anyways, April had about 130,000 people applied for those 33,000 spots. So it was really competitive. And what you ended up seeing was about a 25% likelihood of success. And basically all of those are in the group A. So, in early January, your likelihood of success of getting workers on October 1st. But in all likelihood, you can still get your workers. It'll probably just be June or maybe even July, because almost all of our clients whose applications did not yield workers on April 1st with the certified application secured workers under the cap increase. So there is that option, and that option is extremely useful. Now, one thing that's extremely important for H-2B filings, it's so important that this is one of our core values in our law firm, and that is timeliness. So timeliness is one of our core values and is the key to success for this whole process. That's timeliness on our side, meaning when we get something, we don't wait on submitting it. We don't wait on the Department of Labor, or we don't wait the time frame that we're technically allowed to wait. We just go. And that's because we can control our timelines. We can't control the timelines of the government. But the other thing is we expect timeliness from our clients. So when we request documents, we expect them to be timely provided to us. We understand the complexity of the program, which is really nice. So we actually know the regulations. We file a lot of these applications. We act as strategic partners with our clients and advising them on how they can file these applications in a successful way. So we know prior to filing the application, your likelihood of success. We know the things that the Department of Labor is going to look at. And so we help you come to we help you meet the regulatory requirements. So demonstrate temporary nature. How are you going to prove it? What evidence do they want to see? How are you going to prove number of workers? What evidence do they want to see? Those are the kind of things that we have often and continue to help people with. So if you want to learn more about us, you can just go on our law firm's website, farmerlawpc.com. You can find us on any of these various platforms, I suppose. You can also email us at intake@farmerlawpc.com. We'd be more than happy to talk to you. If you have any questions or anything that you want to discuss, we love being a resource to people, whether or not you're our client. So please do reach out to us. I'm going to stop sharing that, and we can move into Q&A if there are any questions. I see no one's asked any questions yet, so feel free, if any questions popped up that you want to discuss, just put them over there in the Q&A, and I'll be happy to answer them. And generally, the biggest frustration with the H-2B program is that numerical cap. And so that's the part where you got to submit applications timely. You've got to respond timely when the Department of Labor requests documents. It's really important. And man, sometimes you just got to get lucky. Okay, so this question is a great question. Do you think a private wage survey is worth it versus using the prevailing wage figure given to you? It can be. So there's also another option for using a private wage survey. I think it just depends primarily on what the difference in the wage rate is. So this is the one thing that I would seriously weigh pretty heavily is Department of Labor is going to scrutinize your private wage survey significantly more than they would the prevailing wage determination. And so let's say you're filing for an April 1st start date. And let's say that the actual wage difference is 20 cents an hour, and I've got 15 people. And it doesn't actually make a huge difference for you. It's probably not worth it, just because they're going to scrutinize it. It could delay your application, and it could end up resulting in you not getting any workers. But if it's a $3 an hour difference, absolutely it's worth it. Yeah, so if you, oh, okay, yeah. So the qualifier is we're in a rural area, so the wages are significantly different than our normal wage, which that I would assume the normal wage is the prevailing wage determination, what the Department of Labor issues, and up to $5 an hour difference. That is a huge difference. Because I mean, if you think about it, just from a dollar per, these people generally work about 1,400 hours over the course of a year. So 5 times 1,400 is $7,000 in additional wages a person. And if you have, let's say, I mean, if you have 10 people, that's a $70,000 a year difference. And so, yeah, I do think that it's worth it. Make sure that your private wage survey meets the regulatory requirements, which are pretty specifically outlined. And then the other thing that I would do is I would make sure that my application preemptively argues the legal basis of our private wage survey. That this question was, has your firm been successful with these private wage surveys? We haven't used them because it hasn't been necessary for us. We certainly could, though. I mean, I don't have any issue with that. The regulations are clear on what they need to be, and doing a private wage survey is definitely doable. But the other thing I would be sure to take into account is the amount of time that it takes. So do it pretty far in advance. Give yourself some latitude to still file a supplemental prevailing wage determination if you want to. The other thing you could do is you could file both. You could do a prevailing wage determination and do the alternate wage survey. So in case they denied it, but you still wanted your workers, you could maybe supplement it with a prevailing wage determination and ask them to change your application. That way you don't lose your start date. So that's another potential option there. That's a great question. People don't use private wage surveys a ton, just on a statistical basis, but $5 an hour, that's enormous. That's definitely worth it. All right. Well, thank you all so much for participating. Thank you for the questions. If you have any other questions, feel free to email us, intake@farmerlawpc.com. You can get on our website and reach out to us that way. I love talking to people, love strategizing with people on how they can file their applications. That's what makes my job fun. So please do reach out, and I'll talk to everyone soon. Thanks.